We have Seymour. Yep, we have.
Okay.
We're good.
Good morning, everybody. Welcome to our January 2014 meeting of the Joint Commission on Public Ethics. We have commissioners here, and we have commissioners who are participating by Skype. To begin, can we have any comments on the minutes from our meeting of December 30th? If there are no comments, I'll take a motion and a second to approve the minutes. Second. All in favor of approving the minutes? Aye?
Aye.
Everybody, I think for the Skype participants, let's just raise hands so we can make sure that we have everybody. Mitra, Seymour, can you hear us? Yes?
Yes, I can hear.
Oh, okay. All right, the minutes are approved. Letitia, actually, before we start, forgive me because I meant to open the meeting by introducing our newest member of the commission, Paul Castellero, who joins us to replace Ellen Yarashevsky. And as I said at our last meeting, we thank both Commissioner Yarashevsky and Commissioner Vincent DiOrio for their service as original members of the commission, and we welcome Paul, and we look forward to working with him very much.
I look forward to it too.
Thank you. Can we have, Letitia, please, an update on 2 points, training and our third quarter financial report, please?
Certainly. Good morning, everyone.
Chair,
Yes? Commissioner Jacob?
has an appointment been made to fill the vacancy created by Commissioner DiOrio's resignation?
I haven't gotten a press release or a notice on that, have you?
Because it seems to me that the 30-day period flagging that appointment may have come and gone. Am I right about that?
I don't know. I'm quite sure that we will have another appointment, and I'm sure when we have that appointment, we'll welcome that new commissioner as we've welcomed all of the new commissioners.
Thank you.
You're welcome.
Continue.
Yes, please.
Okay. Training and education continues to be one of our highest priorities, and we are committed this year to expanding our training programs and our outreach. One of the things that we're anticipating is when we finalize the gift regs that we're going to have a rollout, which will include training sessions, it'll include new materials in plain language. We're also developing the first lobbying training on ethics, and we'll be working on that and reporting on that shortly. At this time, I'm going to turn it over to Sherry Calnero, our manager of training, and our senior counsel, and she's going to report to us on the online orientation that she's been developing on ethics.
Thank you, Leticia. Good morning, everyone. One of Jacob's mandated ethics trainings is the online ethics orientation for those newly subject to the financial disclosure requirements. In other words, those state officers, employees, and other individuals who are required to file an annual FDS with Jacob. Utilizing a new e-learning software, our training unit is finalizing this new course. The next step is to submit the course to the Governor's Office of Employee Relations for testing and quality assurance within the statewide learning management system, also known as SLMS, which is the online portal that makes trainings and other courses available statewide to all the state agencies and to those who need to take this course. Once QA is complete, SLMS will make the orientation available to all state agencies and those who are required to take it via their personal computer. Barring any unforeseen testing glitches, I anticipate that by March 1st, this will be live on SLMS and available. And once the course is available, new FDS filers are required to complete this orientation within 3 months of being hired or becoming an FDS filer. So that's the that's the construct in which this training works. And I'm happy to report on this this new training. If you have any questions, I'm happy to answer them. Otherwise, I will
Any questions?
defer back to Leticia.
Yeah, is there a mechanism to ensure JCO that the training has actually been taken by the new employees and others who may be subject to the requirement?
Within SLMS, there is a way for each agency to track who has taken it, and then in turn that agency reports to JCO.
Okay.
Thank you, Sherry. I now want to turn to Janine Clementi, our Director of Administration, and she can update us on the third quarter financial report.
As of the end of December, the Commission has spent $2,665,000 in total of its appropriation in its cash. We have spent $2,220,000 in personal services and approximately $450,000 in non-personal services. In total, we've spent about 60% of our cash for the year, our cash limit for the year, 61% of the personal services, and 51% of the non-personal services.
Thank you, Janine.
Thank you, Janine. At this point, we should move into executive session to begin.
May I ask the chair? I'd like to raise a point.
Can we, does it relate to the source of funding, Marvin? Because
No, it relates to our schedule
what we're going to,
schedule of meetings.
right, what we're going to do, Marvin, and I'm happy to hear you on this, but for the sake of good order, and I think this will benefit the members of the public who are attending. We will move into executive session to consider that part of the process for the source of funding exemptions that, under our guidelines and regs, must be considered in executive session. And then we'll come back into the public session to continue that discussion. And then, as you can see, Marvin, we've got new and other business there. So if you wouldn't mind, I just ask you
This
to...
is a very brief point.
I'm sure that it is.
Because if I may, we proposed a meeting schedule for the first 6 months of 2014 at our December 30th meeting. We've already blown through one date. I just want to ask that, or move, that we finalize a meeting schedule for 2014 and then we post it on our website so that we become very transparent as to the scheduled dates of our meetings, so that when we do not have a meeting, as happened during 2013, during the summer and then later in the year, at least the public is advised that a meeting has been canceled, and we need to offer to the public a reason for that cancellation. So since we have missed the opportunity of meeting during the summer, July, August, we did not meet, November, December, we've got a lot of business to do, and I'd like to move the commission that we get a schedule of meetings for the year posted on our website, and we stick, as we did in the past, rigidly to that schedule.
Marvin, thank you for your comments. It was a little bit more than a minor point, because you're talking about the schedules of 13 other individuals that, as well as the staff, that ought to be taken into consideration. Having said that, just so the record's clear, our meeting schedule for last year was posted well in advance. There were no meetings that were missed or skipped. We met all of the statutory requirements that we were obligated to, and I don't have the numbers in front of me, but we met many times, and as I think we would all agree, we had a very productive year. That having been said, I think your point about scheduling and consistency and planning, not just for the members of the public, but for the commissioners themselves, is very important. And what I'd ask is, as I have asked when we've discussed the schedule every time it's come up, that we take into account other commissioner schedules and their needs, as we move forward. So thank you for the comment. We'll take it under advisement. If anybody has any thoughts about the schedule, as I said at our December meeting, if anybody's got any thoughts about the schedule, if there are conflicts that commissioners perceive now, please let us know. We will work through those, and we will work through those comments. So thank you for the comment, Commissioner. And at this point, we'll, as I said, let's. Well, I'm happy to hear what other commissioners have to say about.
Putting it on the website?
Sure.
Who cares? Why not?
I don't see a reason why we couldn't do that. I mean, if there are reasons that the meeting schedule has to be changed, that could be noticed as well. I don't see a reason why we don't do that.
Commissioner, Chair, David Renzi here. I just wanted to follow up a little bit on our motion, and I think it's a good push to try and get some solid dates for the year. And obviously, a lot of us are Skyping in today. With today's technology, it's, I think, from a scheduling perspective, it gives us all an opportunity to make it. And I just think that his point is well taken. It adds transparency, and I would second it if it's in the form of a motion. I'm not sure where we're at with it.
Every other word is transparent.
Well, I'm not really sure. Well, what is the motion? Just because I'll just be very direct, as everybody knows. I chair the commission. I also have a full-time job. I'm not prepared at this meeting to plan what my availability will be in September or October. I think I'm good for the dates that we picked through the 6 months. And I'm sure I speak on behalf of other commissioners who have equally full schedules. So I'm not sure what the motion is, that we should post this, that we should
make schedule that was in our book for the December 30th meeting. At the end of that book, you have a proposed meeting schedule of months from January through June. That proposed meeting schedule will be finalized today and be posted on our website.
Do we have a second?
Second.
All in favor? Aye. Any opposed? No, the motion is carried. Thank you. Can we have a motion now to move into executive session so that we may take up the confidential part of our discussion on source
Chairman,
of...
I'm sorry to interrupt, please. Pardon the interruption. Mike Norman from Newsday. Could you please explain what specific provision of the open meetings law you're going to be citing? Is it real estate, investigation, personnel? As you mentioned earlier, it's about process, which I believe you'll find that the legislative portion of your law isn't allowed to go into executive session. Thank you.
Under our rules, it's under the statute. We're not subject to... Okay. Can I have a motion, please, to enter into executive session? A second? Okay.
Excuse me, you have to state your purpose for going into an executive session under the Public Officers Law.
We are about to take up confidential matters under our rules, regulations, and statutes.
Excuse me, Mr. Chairman, the question I had, though, was about what's provision under the open meetings law, which I believe you're subject to for legislative action, lobbying action. Thank you.
We're not subject to the open motions law. I appreciate your comments and your questions. We have a motion that's pending, that's been seconded. All in favor? Aye. Any opposed? Hearing none, we're going to go into executive session, and I'd ask the members of the public to exit now. And when we open the meeting back up into the public session, we'll invite you back in. Thank you very much. Okay, thank you. We've returned to public session. During the executive session, the commission granted 2 applications and denied 1 application for waivers from the revolving door provisions pursuant to Public Officers Law 73 8-B. Also pursuant to our regulations, the commission determined to redact personal identifying information from 3 applications for exemptions from the source of funding requirements. At this time, we are going to take up 4 applications for exemptions from the source of funding disclosure requirements. And before we do that, we're going to have a presentation by Rob Cohen of our staff concerning the legal framework for the determinations we're about to undertake.
So this is just a brief refresher. The Public Integrity Reform Act amended the legislative law, also known as the Lobbying Act, to require that certain entities who are clients of lobbyists or certain entities that lobby on their own behalf disclose sources of funding in excess of $5,000. Specifically, Lobbying Act Section 1-JC4 says that a client filer must disclose sources of funding in excess of $5,000 from a single source when 2 requirements are met. The first is that the client filer spent over $50,000 for reportable compensation and expenses during either one of 2 specified periods in the regulations. And the second requirement is that at least 3% of the total expenditures of the client filer during the same time period, either the calendar year or the previous 12-month period, were devoted to lobbying in New York. So entities, client filers that meet these requirements are required under the law and under our regulations to disclose sources of funding in excess of $5,000 from a single source. The Lobbying Act also provides for exemptions under, again, Section 1-JC4. The source of funding disclosure requirements shall not apply to 501c3 organizations, any governmental entity, and most pertinent and relevant for today's discussion, certain 501c4 regulations. Specifically, if a client filer is a 501c4 regulation and its primary activities concern any area of public concern determined by the Commission to create a substantial likelihood that application of this disclosure requirement would lead to harm, threats, harassments, or reprisals to a source of funding or to individuals or property affiliated with such source, including but not limited to the area of civil rights and civil liberties and any other area of public concern determined pursuant to regulations promulgated by the Commission to form a proper basis for exemption on this basis from the disclosure requirement. So the 4 applications that we have here today are applying for an exemptions under this the 501c4 provision. The analysis under the regs, first, is the client filer registered under Section 501c4 of the Internal Revenue Code? The second question then would be, is the activity upon which the client filer is basing its exemption one of the client filer's primary activities of public concern? And as we just read over here, a primary activity of public concern includes but is not limited to the area of civil rights and civil liberties. Finally, the final question is, has the client filer presented evidence showing that its activity identified here it creates a substantial likelihood that disclosure of its sources of funding would lead to harms, threats, harassment, or reprisals to these sources or to individuals or properties affiliated with the sources. So that's the 3-step analysis under the statute. Now turning to the regs, the regulations provide a non-exclusive list of factors to be considered by the Commission when evaluating a request for an exemption from a 501c4 organization. And I'll just go through them very quickly here. Specific evidence of past or present harms or threats or harassments to the client filer or a potential or a source of funding from the client filer or to individuals or property affiliated with either the source or the client filer. The Commission, under the regulations, may also analyze the severity, number of incidents, and duration of past or present harms or threats, again, directed either to the client filer, one of the client filer's sources, or property or individuals affiliated with either. Another factor is a pattern of threats or manifestations of public hostility against the sources or the client filer itself, or again to individuals or property affiliated with the client filer's source or the client filer itself. Another factor is the evidence of harm, threats, harassments, or reprisals directed against not the client filer or any of the client filer's sources, but to individuals or organizations holding views similar to the client filer seeking an exemption or similar to some of those client filer's sources. And finally, the impact of disclosure on the ability of the sources or the client filer to maintain ordinary business operations and the extent of resulting economic harm. So again, a non-exclusive list of factors that the Commission, under its regulations, is to use in making the determination under number 3 whether the client filer has presented evidence showing that its activities create a substantial likelihood that disclosure of the sources would lead to harm, threats, or harassment.
Thank you, Rob. Do any commissioners have any questions for Rob? Okay.
This is Dave Renzi. I just wanted to question you on the statutory language that you were just pointing out. And I'm looking at the application itself from the first one, and 938.4b, to me, is very specific towards the sources. Primary activities involve areas of public concern that create a substantial likelihood that disclosure of its sources will cause harm, threats, harassment, or reprisals to the sources or individuals or property affiliated with the sources. I don't see where it's specific to the client filer, and the distinction, I think, is significant. Obviously, my concern, and I've been pretty outspoken about it, has been the ability of a special interest to hide assets, resources, fundraising abilities. And I think we need to be clear that we're right on the statute in terms of, is there a significant or a substantial showing of harm to a source? I guess I'll listen to what other commissioners might have to say, or I'll get your comment on that, Rob.
Rob?
The statute is, the statute says what it says, and you describe it accurately. The regulations passed by the Commission and that have been subject to public comment for more than a year now have identified, again, factors that the Commission, a non-exclusive list of factors that the Commission is to consider in determining whether the evidentiary standard should be met. If you're, I don't know
Could
how to.
you just tell us the standard again?
Excuse me?
Substantial likelihood, what the standard is?
It's a substantial. Let me go. Here.
Hold on.
Well, okay. It's a substantial likelihood that the application of the disclosure requirement would lead to harm, threats, harassment, or reprisals to a source of funding or to individuals or property affiliated with the source, including but not limited to the area of civil rights and civil liberties. So,
Thank you.
I don't want to speak for all the commissioners here, but one of the factors, I mean, when the Commission decided upon the list of factors here, there was a recognition, I believe, and the public comments also reflect this, that these entities who are applying for the source of funding disclosure exemptions do not have a history of revealing their sources of funding. So it would be very difficult to point to a potential to acts of violence or threats or harms, threats or harm against a source that has not previously been revealed. So the non-exclusive list of factors, I believe, are a recognition of this fact and allow client filers to seek exemptions by pointing to threats of harm against itself or entities that hold similar views to the client filer.
But see, that was my point. I think that's to me a substantial reach. I mean, the statute to me is pretty clear. If there's an indication that there's a substantial risk of harm to an individual or a source of funding, then by all means make a showing of that, and there would be entitled to an exemption. But for us to speculate that there's going to be, when there's been no evidence submitted, I've got a significant problem with that. I mean, there's not one piece of information that's been submitted in the application for the first one we're reviewing. And again, it's all been redacted, but it's specific to doctors and nurses and certainly things that are caused to concern those individuals, and it's certainly a very controversial issue. But again, my focus is here, are we going to allow a special interest to hide their source of income without them meeting the burdens of the statute?
But if the entity can show that they're receiving threats, and previously they haven't had to disclose their sources, isn't it fairly strong circumstantial evidence when the entity and the people that work for the entity are being threatened and harassed, and that if their sources eventually disclose it, that those same kinds of threats are going to go after the sources? I mean, it's just only logical, I think. I mean, in the law we recognize.
Please let Paul finish.
In the law we recognize circumstantial evidence, and that's what we have here at this present stage, since they haven't previously had to disclose those sources. And we have evidence that the entities themselves and the people that work for the entities and like entities are being threatened and harassed.
Let me just say parenthetically a couple of things. First of all, clearly the statute, Dave, as we all know, as it should, tilts heavily in favor of disclosure. Number one. Number two, the Commission has spent a lot of time, working hard to come up with regulations that balance the concerns that Paul articulated as well as you have. Having said that, Dave, and I think we've discussed this, to the extent that the statute of the source of funding regs are not yet finalized, they will be, I expect, an agenda item at our next meeting in February. And to the extent that the Commission would like to consider any further modifications to the regs, whether it's on the point you raise about what the substantial likelihood of harm means or anything else, it would be my expectation that those changes, if the Commission would like to consider them, will be discussed at our next meeting. Okay, and I appreciate your comments, both Dave and Paul. Thank you. Can we now turn to the first application for exemption, which is from Family Planning Advocates of New York State? And I will open it up to any discussion. If any commissioners would like to discuss this application for exemption. If not, I will then call for a motion, if there is one, to consider to adopt an exemption for family planning advocates from the source of funding disclosure requirements.
So moved.
Is there a second?
For what period, Mr. Chair?
If a commissioner wants to make a motion for the application, let me withdraw. Is there in the application staff a time period for the exemption? Rob?
No, there is not.
Okay. Does any commissioner want to make a motion on this application? Gary?
Memory may fail, but didn't we have a discussion earlier about limiting all of these to 1 year?
Don't hear you, Gary.
I am maybe My memory is failing me, Marvin, but it seemed to me we did have a discussion about limiting all of these to 1 year, if they were granted.
I think you're right. There may have been a discussion about whether there ought to be a limitation, a time limitation, but because we have not considered these applications, what I'm asking commissioners, Judge Roth, you're offering a motion, Commissioner Jacob has asked whether or not you're going to place a time limit on your motion with respect to the application. Pardon me?
No, I don't need a time limit.
Okay, so Marvin, the motion by Judge Roth has no time limitation. Is there a second?
What does that mean? That if the application is granted, it's an evergreen, it's forever?
Judge? It's your motion.
As far as I'm concerned, yes. I don't think that we're required to put a time limit. They have to apply how often?
Never. If you approve it the way you...
They have to file, they have to file their disclosure forms, correct?
So just so everyone understands that this is part of the filing with the client semi-annual report, which is filed on January 15th and July 15th of each year. And at these applications that are before the Commission at present, at a minimum, cover the July through December 2012 period, the January through June 2013 period, and the July through December 2013 period. And so the question, I guess, to Judge Roth is whether your motion covers just those 3 periods. And so the groups would have to reapply on July 15th, 2014.
No, I would, if there's interest in my amending this, have it run through 3 years.
Are you amending your motion?
I'll amend my motion.
Okay, so the motion is to grant an exemption for family planning for a 3-year period. Is there a second?
I'll second it.
All in favor of the motion, raise your hands, and let's keep your hands up so that we can count, please. Let's have a roll call. Judge Roth, Paul, anybody else? Okay. The motion clearly, and, pardon me? Okay, the motion does not carry. The exemption is not granted. Is there, let's take up, unless there's any further discussion, let me just say parenthetically before we move on to the next application. The law requires that when an application is denied, that the Commission provide a written explanation for the grounds of the denial. There is also a time frame in which the applicant, whose applicant is denied, can notice an appeal, if you would, of the Commission's decision. It is the Commission's view that that time period, which I believe is 15 days, will not run until such time that the Commission issues its written decision explaining the rationale for the denial of the exemption, so that any group whose application is denied, it is our view that your 15 days to file an appeal will not run until our written decision is issued. Okay. Unless there's any further discussion on family planning, advocates.
Was there a Judge Roth's motion did not carry, and that was for a period of 3 years. Was there a motion made by anyone for a lesser period?
No.
I would make such a motion.
Okay. Is there a second?
How much lesser?
How much?
In accordance with the time period Monica Stam just earlier described, through July 15, 2014.
So your motion is to grant an exemption to family planning advocates for a period of time running through
to July 15th, 2014. So they would have to reapply on July 15th, 2014.
Okay, is there a second?
What is the next filing period, please?
July 15th, 2014. The filing...
And after that,
December 15th, 2014.
It's every 6 months.
Sorry,
Judge.
January 15th.
It's every
sorry.
6 months. That's right. January and July are the filing periods, Judge. Is there a second for Commissioner
well, would
Jacob?
you accept a year,
This is more than,
Commissioner Jacobs?
this is more than.
Yeah.
I thought I was moving.
It's retroactive, Judge. It's more than a year.
I was moving through July 2012. I was making a motion for approval through July 15, 2014. I don't understand your question, Judge Brewer. What date do you have in mind?
Well, January, the filing period after the July, because that just gives us 6 months, which I don't think we want to take this up again in 6 months. It would seem to me that it's reasonable to give the exemption for a 1-year period.
Okay, so
I will adhere to the motion I made.
all right. There's a motion to grant an exemption to family planning for the filing period running through July 15th, 2014. Is there a second for that motion?
I second it.
All in favor, please raise your hand and say aye.
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 Okay.
Marvin's not even voting.
No. Mr. Jacob and Mr. Roth and Paul. The motion does not carry.
How about a period of negative time?
Okay. Is there any further discussion on the application for family planning advocates? Okay, hearing none. Let's move on to the next application, which is from New York Women's Equality Coalition. Is there any discussion among the commissioners regarding this application? Hearing none. If any commissioner wishes to make a motion on this application, now would be the time to do that.
I would so move through July the 15th, 2014.
Is there a second?
Quick learner.
Is there a second
Looks
for
like
the
Marvin.
motion? Marvin? Okay.
Yeah.
All in favor of the motion, please raise your hand and say aye.
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 I believe it's 3. The motion does not carry. Is there any further discussion or application regarding the New York Women's Equality Coalition? Hearing none, let's take up the next application, which is an application from New Yorkers for Constitutional Freedoms. Do any commissioners wish to discuss this application? Hearing no discussion, if a commissioner wishes to make an application to grant an exemption for New Yorkers for Constitutional Freedoms, for an exemption from the source of funding disclosure requirements, now would be the time to do that. Is there a motion? I hear no motion, and so therefore the application is denied. Finally, The last application for exemption is from the New York Civil Liberties Union. Is there any discussion on this exemption application?
I'd just like to say, with respect to this application, I thought it was a really compelling case that they made. They've shown not only threats to they've shown threats to the individuals that have worked for the ACLU. They've shown threats throughout the country, and it's been a consistent period of time in which they've been receiving the threats. And I think many of us know from following the news of some of the horrendous examples of where the ACLU has been attacked for their various positions. I think the statute itself was almost crafted for the ACLU and organizations like them. They're quite clearly an organization that's concerned with civil liberties and civil rights. I think they've shown from their submissions that, in fact, they face a substantial likelihood that harm would come to some of their sources of funding based upon the threats that have been leveled against them over the years. And I would urge the Commission to grant this exception.
Thank you, Paul. Any further comment or discussion on this application? Hearing none, is there a commissioner who wishes to make a motion to grant an exemption for the Civil Liberties Union of New York from the source of funding disclosure requirements?
I would move, so move.
For what period of time, Paul?
Be consistent through July of 14. Excuse me.
14? Okay. All in favor, please raise your hands. That's 3. The motion does not carry. Okay. Again, the time period for these denials in the Commission's view will run from the date that the Commission issues pursuant to the statute, a public rationale for the Commission's decision, and that decision from the Commission will be forthcoming.
One question, Mr. Chair.
Yes.
You mentioned earlier that a decision had to be written regarding the denial. If that is so, is there provision in the statute or otherwise for the writing of a dissent?
No, there's no provision that I'm aware of in the statute for the writing of a dissent. I'll turn to staff, but my understanding of the statute is that the statute simply requires that the Commission provide a written explanation for a denial of an application for an exemption from the source of funding disclosure requirements. The language, I believe, in the statute and the regs is silent on a dissent.
I don't know what kind of reasons we would give for denying this because I've really not heard anything. And the statute, or this part of the statute, was enacted specifically for these kinds of organizations and to protect them. And I don't think we have done our jobs.
Right, who is gonna be making up the reasons? Nobody stated a reason. There's been no discussion, motions were made, and there was no negative comment on any of them, just a negative vote.
Well, if I can chime in, at the beginning of the process, I discussed in theory the statutory issues I had with it, and I think that was consistent with all of them. And my votes were based on, I don't think they met their statutory burden. It's that simple.
But I understand that, Commissioner, but who is when we write a decision, who is saying what? I mean, someone's going to be making up a line of reasoning justifying the denial, but where is it coming from? I mean, is it the staff? The staff is then denying it? I mean, who's denying it?
The staff is not going to, as I believe we've discussed previously, the process is that the commission will consider language, perhaps the staff will prepare it for us, but obviously, whatever the commission decides to write on this regard is going to be subject to the views of the commissioners. And that is a process that we will move forward with.
Do we all
George?
then? Oh, I'm sorry.
I think the overriding view is one of transparency. I mean, and we've said this in many different ways.
Defenders of the Constitution at risk? I mean, you know, Judge Bianco
May I
was
just,
the head of
you mentioned, the chair mentioned at the outset that an appeal may be taken from denials after a decision is written. Now, it seems to me, from the comments that are being made by Judge Roth, that if Judge Roth or someone else wants to write a dissent, that ought to be permitted, because it will facilitate it will help the person who gets that decision clarify in his or her mind whether an appeal would make any sense. We're not sitting around the table arguing pros and cons, but if there is going to be a decision written, and several commissioners have gone the other way from the majority in the voting, shouldn't those commissioners be given an opportunity to write a dissent with regard to the decision? It will be helpful insofar as the applicant's decision to appeal would be helpful if an appeal takes place for a court to review it. We ought to be open in that regard.
If I could make a comment, this is Mary Lou. Sorry I'm not there, and sorry striking this morning, but it is what it is. I think there's some institutional memory here, as much of an institution as JCOPE is for the short period of time that we've been in operation. But the first time one of these came in front of the commission, there was a great deal of conversation, and amounts of time were discussed. Dave Renzi, your points were discussed. I can't remember, you were on the commission, of course, at that time. I think, Marvin, your point is well taken, and I personally would like to write some thoughts by way of institutional memory as how we have come to the place we are today.
Well, this is an enormously important area of the law that we regulate, that we're active in. And we ought to be very clear about the decisions we make in this area and elicit from those who are opposed to the majority their thinking. Because in my view,
Marvin, let me interrupt
they
you.
end up on appeal.
Marvin,
Joe?
Procedurally, I mean, obviously, if there is a majority, the minority might get a chance to write, but I think what happened here, and I could be wrong, there was an application to approve something, and there weren't enough votes to carry it. How is there a minority and a majority? Where is there a majority decision? I mean, eventually we're going to write something, I assume, that says that we don't believe it comported with the requirements of the statute, and that transparency is more important. And that's about it, but there's no majority vote here. There was a failure to muster enough votes to pass something.
Correct. And the other thing I would add,
It would be
the other thing I would add,
inconsistent with
Marvin,
the facts
is that
of what
the other
happened
thing,
here.
the other thing I would add,
The decision were written, and there were no comments in that decision or no indication in that decision that the decision was not unanimous.
Well, I imagine the
There
vote's
was
going to
no
be in
unanimous decision around this table.
the vote's going to be in the
There is no
decision.
unanimity. Those who oppose ought to have an opportunity
Marvin,
to state
would you,
their reasons.
thank you, Marvin. I'd like to hear further from Joe, because I'm sure it was just a connection, but there was a point there where you were talking over him, and I think he was trying to make a point.
I thought it was
Can
my
you
turn.
finish, Joe, what your point was? Thank you.
Yeah, Marvin, I imagine the decision is going to reflect our vote. We just did it in public. There's nothing secretive with regard to our vote. And I can't imagine as a person in the room who doesn't believe that there wasn't enough to support the motion that they had comported with the statute and that there was significant evidence here to establish that a grant should occur. So who's the majority, who's the minority, I don't really know.
Well, what I envision, Marvin, for the next meeting, at least, irrespective of your question about a dissent, is that there will be a written decision that will be presented to the commission for approval at the next meeting. And if that written decision says something along the lines of that, you know, in the spirit of the agency and our underlying statute, that the law favors transparency, that a majority of the commissioners have determined that the legal standard for each application was not met, if that's what it says, then that'll be put to the commission for a vote. With respect to the applications themselves, I mean, they're public. And I think, you know, certainly Paul and you and Judge Roth, you know, have had an opportunity and took that opportunity to explain why you thought these applications were meritorious. So I think, as I said, we'll ask the staff to prepare something subject to our approval, which we'll take up at the next meeting. And we can give some further thought to whether, under these kinds of circumstances, a dissent is called for. I mean, as I said, and I think as Joe said, I mean, the applications speak for themselves. So, in any event, let's give some further thought to the prospect of a dissent. In the meantime, we'll ask the staff to prepare and circulate to us a written rationale consistent with the statute that we can then consider and take a vote on.
If you're finished.
Pardon me?
Are you finished, Dan?
I am.
We are in public session.
Yes, we are.
So it will be clear to everyone who's watching this that there was a different view, and I think that different view should be able to write about it. If you're going to say there wasn't, or have the staff say there wasn't sufficient evidence to show likelihood of harm, I think those who believe there was sufficient evidence should have the opportunity to say so.
Okay. Oh, hold on.
I agree. I think Lisi wants to say something.
I agree. I think if, you know, to the extent people think there is a dissent and that there was enough for the exemption to pass, they should be able to write on it.
Okay. All right. Well, if people want to submit something to the staff for consideration along with whatever the staff puts together for the majority, I encourage you to do that, whether it's Mary Lou, I think you said you were thinking about putting something together, or Judge Roth, if you'd like to, or Marvin, Paul, I think that's fine. Okay. You're welcome. With respect to an application that the Commission considered and granted earlier in the year regarding NARAL New York, on June 25th, 2013, the Joint Commission granted NARAL New York's application for exemption from the source of funding disclosure requirements. That exemption was granted for a period running through 2016. Since that time, significant amendments have been made to the regulations, including provisions increasing the transparency of the process, as well as a revision to the threshold standard adhering to the statutory language. Recently, at the direction of the Commission staff and NARAL representatives engaged in discussions regarding the exemption. Both the Commission and NARAL New York now agree to revise the exemption granted in order to be consistent with the standards, practices, and procedures that will apply to all applicants. That being the case, NARAL New York's exemption granted in June will now remain in effect until the filing date on July 15th, 2014. For that filing, NARAL will have the opportunity to submit a new application for exemption pursuant to the revised regulations. At this point, I will entertain a motion to enter into executive session pursuant to Public Officers Law, Section 9419B, to discuss certain investigative matters and other confidential matters. Do I have a motion? A second?
Second.
All in favor? Aye. Thank you. The motion carries. To go into executive session. It was Executive Law 9419, not Public Officers Law. That's right. Okay. During the executive session, the Commission discussed several investigative matters, including some investigation, authorizing further action, and others, and approving one settlement agreement. And unless there's any further business, I'll entertain a motion to adjourn.
So moved.
Second? All in favor? Aye. Any opposed? No. We're adjourned. Thank you very much. We'll see you on February 3rd.
You're the best, brother.